Okay, we're on the record. Mr. Blumberg, I'm sure that your client is going to, here I know he was having some kind of surgery within our last hearing.
Yes, Judge. So had the cardiac surgery.
Okay.
He's just got released from the hospital. He's in no condition actually to come in court. So we asked the court perhaps to put this over for 30 days, or maybe I can file a motion to address the issue of sentencing in this matter.
I do not have an objection. I did read all of the medical stuff. It sounds like he's not in a position to be incarcerated at this point. I believe he's currently inpatient hospitalized. And Mr. Butler and I talked about alternative to sentencing if the court would consider him, which would consider tether. We don't ever do that, but this is obviously an exception, not the rule. And so he was going to do some research into that. And because of all those things, I wouldn't object.
Okay, so we'll adjourn this for 30 days.
Thank you, Judge.
I'll give that back to you, Mr. Clover. Okay. And then if you and Ms. Koch, I'd be, get to considering options. I'm satisfied that Mr. Clover's
Thank you, Judge.
it's a legitimate health condition. So work on that charge.
Great. Thank you.
Thank you.
Thank you, sir.
Mr. Davis, ready.
Your Honor, I believe that the probation department is intending to dismiss that violation.
Okay, so this is People versus Edward Davis, case number 214807.
Mr. Davis called me this morning and asked me for the Zoom number. I don't know if he's available by Zoom.
Mr. Davis there.
Yes.
All right, so we do have Mr. Davis connected.
Well, Your Honor, he has completed residential treatment. He's in a sober living house at this time. He's also employed. With his progress to this point, I would look to ask the court to dismiss the violation.
All right, Mr. Treese, I'm assuming you don't have any objection to that.
We do not, Your Honor.
All right, so Mr. Davis, the court, based on Mr. Davis' representation, that's that feedback. Based on Mr. Haven's representation, the court is going to dismiss the probation violation in this case. And Mr. Haven, is Mr. Davis aware of his next report date?
Your Honor, he was transferred up to Petoskey, and he has scheduled report dates with his agent there.
Okay, so Mr. Davis, just make sure that you report as scheduled with your current supervising agent. And that's all for today. You're free to disconnect at this time. People versus Krista McLean, case number 235193.
Here, on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of this.
The date and time set for a sentencing hearing in this matter. You had a chance to go through the pre-sentence report. Mr. Church.
Yes, sir.
Mr. Church, are there any additions, deletions, or corrections that need to be made to that?
No, Your Honor.
Well, misdemeanors, so no guidelines. Ms. Koch, do people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people?
Your Honor, I think the recommendation is appropriate. She has, almost no criminal history. I think this is the circumstances of her own making. I think the recommendation is appropriate. I asked the court to follow it.
Thank you, Your Honor. I guess I would indicate I think most of the recommendation here is appropriate. We do take some umbrage with the recommendation for 5 days in the county jail. that would seem to me to be inappropriate given the circumstances. Ms. McLean has a single prior conviction, which is almost 10 years ago. The offense that she's before the court for right now is a misdemeanor offense. I think that the report accurately captures some of the things that happened here, which is really that I think alcohol was the driving factor behind this. And Ms. McLean has no objection to engaging in the alcohol treatment and abstaining from alcohol. I think she recognizes it's a good idea for her. She's even taken the steps. She was working at a bar and is now obtaining employment in a different place. I think a retail store. She's about to start at. Sorry, you said it was called Chuck's. She's the primary caregiver for her 4 children, and when I say primary caregiver, I mean the fathers are really not involved in the care. And I would suggest to the court, as I think the court's probably aware, this sort of what I'll call a micro jail sentence, right? This sort of short jail sentence, I think, is likely to set her back more than really serve the purposes of rehabilitation here. It likely would have an impact on the job. It's likely to have an impact on the 4 kids that she's taking care of. And I would ask the court, I don't know that there's a lot of what I would call value gained from it in terms of putting her in jail for an additional 4 days. What does that really, what does that really serve in terms of deterrence or protection to the community? Versus even holding jail over her head and having her follow the recommendations here and engage in the appropriate alcohol treatment, I think has a much better prognosis for her success. I would also indicate, the court would probably note that she has a cast on her hand. She has a broken finger that's scheduled to have surgery. Did you say next week?
I have an appointment at 9 a.m. tomorrow to start surgery process.
So for all of those reasons, I would suggest to the court that the recommendation seems appropriate. I would ask the court to consider holding any jail in abeyance, even if the court held more jail than the recommended 5 days, but held in abeyance. I think that would serve the interests both of deterrence as well as encouraging her to continue on a sober path.
All right, thank you, Ms. McLean. Anything you wanted to say?
No, I don't think so. I agree with him. I feel like I don't think I'm gonna get anywhere sitting in jail. I have to go pick my sons up from cross country and football practice after this. I have a 6-year-old that doesn't have an involved dad. All my kids are without their dads that are the older ones, and I just don't think that I'm sitting away from them is gonna do them any good.
Okay, well, you're right about that, but unfortunately, that's typically not a consideration. A lot of people that get themselves into trouble and come before the court have children.
Like you said.
That's one of the really unfortunate collateral side effects. Your kids end up paying the price for something that you did. That's something that you have to understand, that the only person you can lay that at the door of is yourself.
Yeah.
So that's not a reason for the court not to give you jail time, and neither is your injury. That's something that can be taken care of. I do agree, though, generally with what your attorney said in terms of holding the jail time over your head, and that's based on the circumstances here and your past history, which is really minimal. You're not somebody that spends a lot of time getting yourself into trouble. So I think it's appropriate to give you an opportunity to not have those kind of consequences to your family by having some probation with jail time held over your head. The court is going to place you on probation for a period of 1 year. The court is going to adopt as the conditions of the probation all the terms and conditions listed in this report. The court is going to impose 30 days of jail. I'm going to hold that in abeyance. So if you comply with the probation and you don't have any problems, you'll never have to serve that time. If you don't, though, you'll have to serve that 30 days. So you will have an opportunity to avoid doing that by complying with your probation. You do have credit for 1 day served. The court is going to order a crime victims assessment of $130, or cost of $325, attorney fees of $350, $100 in state costs, and a $30 per month supervision fee while you're on probation. You do have the ability to appeal this sentence, and because it's a misdemeanor, I don't think those are appellate rights.
They're not, but I do think the court probably does need this.
Okay, thank you. If you wanted to file an appeal of the sentence, you would need to do that within the next 21 days. If you have more questions about that, Mr. True should be able to help answer those questions. Other than that, you just need to make sure, Mr. McFeld, are you the supervising agent?
Yes, Judge.
So just talk to Mr. McFeld before you leave the courthouse today.
How long do I have to pay the?
That's something you can work out with Mr. McFeld.
Okay, thank you.
All right, thank you. People versus Carrie Ford, case number 235209.
Sierra Coke on behalf of the people.
Mr. Trush, can you tell me where you're at with this case?
So, Your Honor, I believe we're here for a violation hearing on 22-5139 FH. And then our first status conference on 23-5209 FH. And the new case forms the basis for the violation of the old case.
Okay.
With all of that sort of history or background in mind, we intend to resolve both of these matters today by making admissions.
I only have one case set for today, and that is 5209.
I actually do have both of them on the docket, on my docket.
Was that added on Friday?
I don't have it on my docket, but 5209 is the new case, which is the one that was originally scheduled. I'm assuming they just added the violation.
That case number, or is it the same case number?
No, it is 22-5139, and that. All right.
What we talking about, the violation?
Yeah.
I would recommend that we don't address the violation today, because is she pleading on the new file?
Correct.
There's a high likelihood I would just use that as a sanction and ask that be dismissed. Judge.
Okay.
5139 is set for PV on 10/16.
Oh, okay. All right, so.
Well, it looks like
let's-
maybe we won't even need that here.
Right, yeah, so perhaps that will dismiss. So can you tell me as to file 235209, what the term is?
Ms. Ford, plead count one, the announcements will be dismissed.
It is.
Ms. Ford, have you had a chance to talk to Mr. Trush about this plea?
Yes, I have.
Is that how you want to proceed today?
Yes, it is, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And Ms. Ford, you understand that because you were on probation at the time, that there is a potential that this could result in a violation of your probation and additional penalties for that, although as we've heard Mr. Felder, it sounds like that may be dismissed, but you need to know that is a possibility. You understand that?
I do, Your Honor.
And the maximum possible penalty that you could face for this charge, which is possession of methamphetamine, is up to 10 years and or $15,000 fine.
Yes.
With all of those things in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights.
I do.
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anybody promised you anything other than what we've said here in court today?
no,
Is it your own free choice to plead guilty?
yes,
Are you pleading guilty because you are guilty?
yes, Your Honor.
This happened on July 27th of this year, is that correct? On that date, were you present here in Crawford County? And on that day, while you were here in Crawford County, did you have possession of methamphetamine?
Yes, Your Honor.
Did you know that that's what that was?
Yes,
Did you have any legal right to have any amount of methamphetamine?
no,
Ms. Coke, are the people satisfied with the factual basis?
Yes, Your Honor.
We are satisfied.
Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
We are aware of that.
Ms. Coke, are the people satisfied that the court has complied with statute or rule?
Yes, Your Honor.
Mr. Church?
We are satisfied.
The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's okay. Further we need to address at this time.
No, Your Honor.
There is a bond issue we need to address.
Okay, so bond was revoked. It's, is it a positive drug test or something like that?
Yes.
Okay. All right, so bond has been revoked. What's your request on that?
So, Your Honor, I believe that Ms. Ford has been in the county jail for about a month. There's no question that she's struggling with addiction. I would ask the court to consider, even if the court placed a high bond but gave her a condition to allow her to be released for rehab. Ultimately, in the best interest, both of Ms. Ford and the community in general, getting her into a rehab program where she can start to address these issues is important. Unfortunately, on the first case, again, she didn't have a lot of history, and I'm not convinced that we put enough intervention in place, and we wind up here with the second one. So I would ask the court to consider modifying the bond in such a way to allow her to be released, but only released to a rehab facility, an inpatient facility.
All right, so I think at this point, the court's gonna have bond remain revoked in light of the plea today. That's something that we can talk about at your sentencing hearing, Ms. Ford. I think that's better addressed to your sentencing than it is prior to that. And so to the extent that you want to seek treatment though between now and your sentencing hearing, whatever you can do towards getting that set up, will increase your chances of being able to
thank you.
versus Nicole Myers, case number 235185.
Here, Coke, on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Myers.
Trush, where are you at? Looks like we had a hearing back in July. What has happened since then?
That is correct, Your Honor. We have a agreement that we would seek to enter into today, whereby Ms. Myers would plead to count 1, counts 2, and the enhancements would be dismissed.
Oh,
That is correct statement of the offer.
had a chance to talk to Mr. Trush about this plea agreement.
Yes,
Is that how you want to proceed today?
yes,
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Byers, are you currently on any kind of probation or parole?
No,
And you understand that the maximum penalty that you could face for this charge, which is delivery or manufacture of methamphetamine, is up to 20 years and or a $25,000 fine.
yes,
With that in mind, what is your plea to that charge today?
guilty.
So as I told Ms. Ford before, I went through her rights with her. I'm gonna go through yours with you as well here directly. You understand that you have the right to have a trial. You have the right to be tried by a jury. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand that you have all of those rights.
I do.
Giving up and waiving all of those rights, including the right to have a jury. So you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. They said no, then that would be the end of any appeal. You understand that?
Yeah.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court?
No.
Choice to plead guilty.
Yes.
This happened on August 22nd of last year, 2022. Is that the correct?
Yes.
On that day, were you here in Crawford County?
Yes.
While you were here in Crawford County, did you give or sell some methamphetamine to another person?
Yes.
And did you have any legal right to give or sell that to someone else at that time?
No.
Both are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Trush, are you?
Defense is satisfied.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, thank you.
Mr. Trush, are you?
I'm aware of none, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Mr. Trush.
Defense is satisfied.
Ms. Myers, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. We're gonna meet with one of the probation agents before you leave today to set up a pre-sentence report interview. Prior to the sentencing hearing, it's important that you stay in touch with Mr. Trush, so we can go through that report and so that you're prepared for that hearing. People versus Shepherd, case number 235179 and 235180.
Sierra Coke on behalf of the people.
And Mr. Gerber,
No, I just got retained on Friday on this matter.
okay, all right, so Mr. Shepherd, both files, the court issued a bench warrant for failure to appear. Last hearing, I believe, there's a long string of issues with Mr. Shepherd appearing in court. I did receive some documentation, though, that substantiates the foot injury. So we have that. I think the last hearing, the call from your wife was about.
Correct.
So, how do we want to proceed today, Mr. Gerber?
So Judge, I think today was set for, by way of a motion to consolidate. I haven't gone through this file with Mr. Shepherd. I would just ask that we adjourn all of those pending issues for at least 30 days. There's a good chance of resolution. I haven't had a chance to speak with Ms. Colby or the jury trial here prior, so I like that opportunity to before these out. But by way of bond, I think I've narrowed down the issues. Mr. Shepherd indicates he'd hired an attorney out of Grand Rapids. My understanding is nobody filed an appearance. His understanding was that things were taken care of. He didn't have to be in court. Clearly, that's not how this works. I think Mr. Shepherd understands. Then at the next show cause, since the other attorney didn't, Monica Peters, and that's the name he gives me, the attorney who's in Grand Rapids, didn't file an appearance. he was in the process of then retaining somebody on Home Lake, Miss Sally Hamlin. He had not retained her, but I think she had reached out to Ms. Coke on a Friday, indicating that there were some issues with non-appearance, foot injury, there was some discussion. And indicated that as long as you retain counsel and an appearance was filed by Monday, a bench warrant would not be issued. He was in the process of doing that. And then a warrant was issued, it was picked up Friday. There has been no issues of him absconding or trying to evade these proceedings. His wife's here in court. I've verified his address. I made sure that they open a PO box. There is a no PO box address, but he's gonna get mail. And I've indicated to him he has to appear for every court proceeding, regardless of whatever those excuses are. There are no excuses to be made. The attorney appears, and the client appears with the attorney when there's a notice to appear. So I don't think there's going to be any issues going forward. Employed, he's got 2 kids at home, his wife's here. So I think I would simply ask the court to reinstate those 2 bonds. They're together a $10,000 or $20,000 bond, so it was a $30,000 bond that he did post. So I would ask the court to reinstate. No issues of drug or alcohol. These original charges stem from some mental health issues. My understanding is he was then evaluated by CMH, was put on meds and was taking his meds. He was going fine. There have been no issues with the victim, in this case, except for what I would classify as stupid non-appeal issues, because it was just very stupid on Mr. Shepherd's part. But I think those issues have been rectified at this point. I don't think we'll have any further issues of these non-appeals.
Thank you, Ms. Coe.
I realize Mr. Gurmuthy is new to this file, and I believe he's probably saying the things that his client said to him, but I don't think that's accurate. I made the offer in March. We had a March 14th hearing, and he could not appear because he was hospitalized. The court just adjourned everything. On 4/18, he didn't appear again. This time he had connection issues. Says he's on a job site. So he tried to call the court. So that was adjourned. Originally he didn't appear, but then he did appear. 4/25, he said he retained attorney Monica Peters from Grand Rapids. He plans to pay her that day, but he waived the preliminary examination on his own and it was bound over. Then we had the 6/20 hearing where he failed to appear. He had his wife call, said he was injured on a site accident, and he required that he show documentation, which we do have, finally. It just says that there was an emergency room physician. And then at the last hearing, he had his wife call and say they all had COVID. When he got arrested, I believe that same day, he never told the jail anything about COVID. He didn't have COVID. There was no COVID issue. I did speak to Sally down in Roscommon. I never told her that there wouldn't be a bench warrant. I never said anything like that. I actually said that there already was a bench warrant for failure to appear. And so far, all of the things they had said to the court hadn't been verified or appeared credible at that point. That's what I told Sally Hamlin at the time. So I don't think that all of these non-appearances and all of these issues are likely to just go away. I hope they do. I hope that Mr. Shepherd appears and we can resolve this issue. The victim has wanted to get this resolved for many months. I would like to move this case along, and I think the court should, if the court does issue a bond, they should issue a new bond. He failed to appear lots of times. Thank you.
All right. I think, Mr. Shepherd, you're entitled to a bond. I don't think the court can deny you bond at all at this point. However, I think in light of the many problems that we've had with you appearing, I mean, every time I see your name on the docket, I can pretty much count on a phone call coming into my office that morning, either from you or from your wife, with some kind of issue that prevents you from getting to court that day. It looks like maybe one of those is actually legitimate, that you did hurt your foot, but none of the other ones are. And so I don't have any assurance that you're actually going to appear before court. We're getting to the point where we're wasting a lot of time and resources because you're not showing up when you're supposed to show up. And so when that happens, the court puts a substantial bond in place so that if you can post it, you have some money on the line to hopefully ensure your appearance. And if you can't, then you're in jail, and we know where you are, and we know that you won't get COVID or hurt your foot or have any other reasons for not being able to appear, we can just bring you right over. And that way we can make sure that your case gets processed in a timely manner, which you have a right to, but the prosecution also has a right. So based on your history with this court, I am not willing to extend you any more leeway. And I think an appropriate bond in each file is $50,000 cash or surety. And that is for the purpose of ensuring your appearance at future hearings. So we'll set that amount. I think it's reasonable based on Mr. Murphy's recent retainer in this case. Give him an opportunity to look at the issue of joinder and consolidation. So Ms. Koch, if you can notice that up, it's a pretty simple issue. I think we can address that. We can notice that up for the court's next full motion day. And then we'll have that heard and proceed on Mr. Shepherd's case at that time. Mr. Gurmurthy, anything else that we need to address?
I would just ask if the court would consider a 10% on the bond.
No, I think that's the amount that we need to make sure that Mr. Shepherd is here so we can go forward with this case.
And 50 on each file, correct?
Yes.
Okay. Thank you.
Thank you. That's all for today, Mr. Shepherd. People versus Baraka or Baracha.
Sierra Coke on behalf of the people.
Are you already on Mr. Townsend's files, Mr. Gurmurthy?
Mr. Townsend.
Townsend?
Townsend, I haven't seen him here. Let me see if he's here. He's not here, Judge.
Okay.
But I'm already in Mr. Butz's.
Okay, we're a little ahead of schedule, so time to talk to him, Mr. Butts at all?
We're ready.
Okay. People versus William Butts, case number 204727 and 214729.
Sierra Coke on behalf of the people.
Thank you already for Mr. Butz. He's here standing my life.
Mr. Gurmurthy, these are probation files. How do we want to proceed?
We would just ask for a 60-day adjournment, Judge. Mr. McFarland agrees with that as well. It makes sense with an idea of having Mr. Butts on probation, see how he performs in this resolve case in 60 days from now.
Mr. McDowell?
That's correct, Judge. Mr. Butts, I would like to monitor him. He's got some new circumstances going with a new job, new living situation. I would like to see, I know he pled to a misdemeanor up in Otsego County. So the felony charges were dropped up there. I think I'd like to see his adjustment here in the next 60 days to kind of decide how to go forward with this case.
Okay. Mr. Butts, do you have any objections to that?
I do not. I would like to change my address because I moved from, Mr. McFarland knows that, but that way the court knows.
Okay,
And
can you give that to Sarah?
okay, it's 7801 Salisbury.
Silsby.
Silsby.
SILSBY Road in Roscommon. Yes, ma'am.
Thank you.
You're welcome. And I have a.
Yep.
Yep.
you're all set.
Thank you.
Mr. McFarland outside. Thank you, Judge.
Cruising through our docket.
Okay, we'll take a short recess. We'll come back on the record at 2:15. ready on Mr. Baraka's case?
Yes, sure.
We're on the record in People versus Eric Baraka, case number 235188. And this is, if I could have counsel put your appearance on. Oh, we don't have Ms. Cook here.
I'm sort of wondering.
Yeah, the monitor was in my way at first. Just assume.
Sierra Coke on behalf of the people.
Thank you, Mr. Truish, on behalf of Mr. Baraka.
Date and time set for delay of sentence hearing in this case. Mr. Baraka, have you had a chance to go through that report? And talk to Mr. Truish, although we aren't technically having a sentencing today. Changes that you made to that report or anything that's
No, you're not.
spoke, any changes that we have.
No,
And Ms. Koch, anything that you would like to say regarding this delay of sentence today?
yeah, and I did read we just got it today, the victim statement from Miss Smith, and you can tell by reading that she's upset she didn't get her restitution, but I think perhaps there was a fundamental misunderstanding about when that would happen. So now that the delay has started, hopefully she'll get that, and I hope that he's successful. He doesn't have, a lengthy criminal history or anything crazy going on. So I hope that he does this and he gets off of it successfully.
So I did not get that victim statement. Can I have a copy of that?
Do you have it? Oh, yeah, just an email. See what I have on my notes.
Okay. I'm gonna include this with my PSI. So, all right. Ms. Koch, anything on behalf of the people that in addition to that?
No, Your Honor.
Mr. Church.
And thank you, Your Honor. I will say I had the same kind of reaction that the prosecutor did when I read that statement. I think it's just a fundamental misunderstanding, and I say that because my understanding from talking to the prosecutor is that the victim was consulted about the delay and was favorable and on board with that. So again, I think there's just miscommunication as far as when those payments would start coming in. And we expect that the payments are going to start coming in shortly after today. Mr. Baraka has a job that he has just acquired as an assistant manager at Wendy's. He indicates to me that he has paid off his final obligation for child support in advance of this. So there's no barriers between him and doing all the things he needs to do to get this paid down. I would indicate to the court, I think his attitude in this has been where it should be. That is to say, he's never made any excuses for what happened. He's been upfront about what he did here. He was struggling with gambling at the time. And again, never denied what happened, never tried to make excuses for it. And from the beginning has indicated nothing other than he intends to try to make this right. So I think the delay of sentence is appropriate. I have no reason to think he won't take advantage of that and do what he needs to do during this time period.
Thank you. Mr. Brock, anything you wanted to say today?
I'd just like to say, Your Honor, I am extremely sorry for what I did. I never had any intentions to hurt Ms. Smith, or, she treated me really good. I had a really good thing going. I did let my gambling get the better of me. It was an addiction that I broke in. I never done anything like this before. I never do anything like this again. I definitely 100% learned my lesson on this for sure.
All right, I did review the report, so I'm familiar with the circumstances that bring before the court here today. And you don't have any previous history. I think the indications are that this was the last judgment on your part. And I think the delay of sentence is an appropriate way to address this, because number one, it's going to give you an opportunity to pass this and not have this become a permanent part of the record. It's going to give the victim an opportunity to get restitution, which is and based on that communication from her. And it provides, I think, both the victim and the court and the community in general with some assurance that if you don't follow through with this, then there is going to be, penalty at the end. So I think all the interests are addressed through the delay here. I think you will be successful. Indications are that this isn't going to be a problem, but you need to know that if you're not, then there's up to a year of jail time. And I think based on the communication from the victim, it doesn't sound like there would be a whole lot of understanding detail to repay that restitution, and that the victim would be asking the court to impose some jail time. So there's a significant consequence to you if you don't. But I do hope that, a year from now, we'll be signing a successful discharge from your delay. The court is going to place you on a delay of sentence for 12 months. The court is going to adopt as the conditions of that delay all the terms and conditions listed in the report. The court is going to make, obviously, the most important condition there, payment of restitution in the amount of $3,766.50 payable to the Crawford County Clerk to be dispersed to 7-Eleven. A $50 state cost, a crime victim's assessment of $130, court costs of $325, and attorney fees of $350. Also, as one of the conditions of the delay, you are not to be on the premises or enter into that 7-Eleven during that period of time. Because it's a delay, there are no appellate rights. Mr. Truce, anything else that you need to address for the record?
No, Your Honor, thank you.
No, Your Honor.
Are you going to meet with Mr. Baraki?
He's coming back tomorrow morning. I already talked to him.
Okay, very good. Thank you. Good luck to you going
All
forward.
right, thank you, I appreciate it.
Can you let Mr. Gerber know?
We do Townsend? We didn't do Townsend here, right?
No.
Okay. We're on the record in versus Chance, case number 2311329. I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
I gotta let it go, Mertz, she's just standing for that.
Okay, so I'm conducting this hearing on behalf of Judge Smith. This is an arraignment on a bench warrant for a failure to appear earlier today. Mr. Gerber, how does Ms. Chance want to?
So I would ask you to set aside the bench warrant at this time. My understanding is that the mail, the notice that went to 60 Beauty Drive address came back. So I don't think she was properly notified for the hearing today. That was one issue, but I did call Ms. Shands this morning, but she didn't appear. And then she did come to court after that, and then was arrested while she was there at court.
All right, Ms. Coe.
Your Honor, actually, the petitioner in this case, when I met with her this morning, she actually was worried. She said when they did a bench warrant, she said, well, what if she didn't get the notice? She said, I haven't gotten the notice in the mail yet either. She's like, I just called because I was afraid I'd miss court. So what would happen? And so she seemed, we would not object to the court doing, just releasing her on the bond. It was kind of the PPO violation isn't something violent. It's just people saying things they shouldn't say.
All right, based on the circumstances, the court will dismiss the bench warrant and any contempt charges related from that. And this was a violation hearing, Ms. Coe?
Yes.
Are you representing
Yes,
Did this
I,
result from an arrest where your office is involved in prosecution?
no, I was appointed to represent the petitioner though by Judge Hunter,
Oh,
so I will be there.
And then I would just state for the record, I would dress strongly in the hallway with Ms. Shands regarding it's social media posts and videos and those kinds of things regarding the petitioner. And I've asked Ms. Shands, so Ms. Cole can indicate to Zoe that Ms. Shands is not to, even if it's on her own Facebook post or her own Instagram and Snapchat, not post anything regarding the petitioner or mention the petitioner. Or have any third-party contact with the petitioner, even though there was no physical violations, physical stalking type behaviors that she's exhibiting, but it's those social media posts that is what brought us here this morning. I think Ms. Shands understands that none of those things should happen.
okay, so the court will just set this for another violation hearing, and I'll let Judge Hunter's staff set that date. For today's purposes, the court again will dismiss the bench warrant with contempt charge, and this chance to be released.
Judge, before we get off the record, when Ms. Chance was booked in, she gave us the address of 60 Beauty Drive again. So what is a correct address for you?
That's the correct address.
The 60 Beauty Drive, because that is where your mail came back from.
Yeah.
That's the address
where
I
live.
checked too.
Okay.
And perhaps Ms. Shannon should call and check if there's another date set, so we don't miss the court date again and go through this again.
Is it avenue or road or drive? Is it?
It's 60 Beauty Drive.
So that's where it got sent, and it came back with a 308 Lawndale apartment 15.
Yeah, I just went to USPS last month to switch over everything. I just got out of my apartment and back with my
Okay,
residence.
so the 60
That's
Beauty Drive
the
is the
reason, yeah.
correct address then for you.
Yeah,
Okay.
I tried switching over my whole family and my boyfriend had a different last name and everything has been going
Okay,
back to my
just
apartment.
making sure, and then you want to make sure you stay in contact
Yeah.
with your attorney.
Go back to USPS and make sure they shut off the old forward.
Yeah, they just got
I
back
would
with
just
me
go
on
back to
that.
the postal service, make sure the forward is back to 60 Beauty Drive.
Yes.
All right, thank you.
Thank you, Judge. I'm ready on Mr. Deno, if you're ready, Judge.
Okay. Versus William Deno, case number 225021.
Here, a Coke on behalf of the people.
Take time set for a sentencing hearing in this file. Mr. Deno, have you had a chance to go through the pre-sentence report and talk to Mr. Crawford about that?
Yes, I have.
Mr. Dermody, are there any additions or corrections to that report?
Not to the report, I would just like to add or request that the court to add the pre-trial release to the PSI as part of the consent.
Okay, I'll order that be attached to it. I did have a chance to review that prior to the hearing today as well. Any other additions, deletions, or corrections?
No.
Are there any challenges to the scoring of the guidelines?
No.
Ms. Coke, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the guidelines?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, I, since I've been elected here, I've dealt with Mr. Deno, I think almost every year on something. And every time I wonder, at what age are you just too old to go down this path? And I think Mr. Deno is far past that age. He's a very nice person. I've seen him outside of courthouse. I've had lots of cases that dealt with his children when I worked in the defense side, so I had to go to his home and see his home for that case. He's always been very nice and very kind. I don't know how he went down the rabbit hole of meth, and I don't know how he's going to get it under control. The recommendation here is at the lower end of the guidelines, which is relatively impressive, given that he was already on, we already had the other case, we already had the other jury trial on the methamphetamine. I think the recommendation is appropriate, and I think the court should follow it. Thank you.
Mr. Gerber?
Thank you, Honor. Mr. Deno's 56 years old. Ms. Coke is right. Mr. Deno's a very nice person to deal with. He's I can't speak enough of how calm and collected he is. I've never had any issues. I've represented him on numerous other matters, whether it's his driving issues or even with his children. He's always very cordial, very nice to deal with, always returns calls, shows up if I need something. So I've never had any issues with Mr. Deno. I'm going to ask the court to do something a little different than the recommendation here, simply because of the history of this case. This case was close in proximity with timing with the previous case that we had the jury trial on. Mr. Deno clearly was found guilty of that case, did 90 days in jail, and then pled to this matter. But what I'm trying to draw is the time frame. When that case started, while this was still pending, Mr. Deno went to rehab. He did have an initial snafu with testing positive. That was about a year ago with the other case that started his I think his bond was revoked, and then he posted a new bond. But since then has been testing negative for all substances. He has been reporting on probation with the other case with Mr. Haven, no violations, no issues. I know I spoke with Mr. Haven this afternoon about Mr. Deno, and Mr. Haven indicates the same thing. He reports he's been testing negative, but that's just what his guidelines are. So I'm going to ask the court not to follow the guidelines and just give Mr. Deno that opportunity to just continue while he's on probation. Put him on probation, whether it's with this case or cut him loose off this case and just continue probation on his other case. But let him just continue with what he did in rehab. He's taking those steps for treatment. He's testing negative. He is employed, and let him just continue doing it. This was not something new that he picked up. It is just a year ago. And there was again the issues of consolidating the co-defendant and other things. And I think part of the delay was the co-defendant's issue of pleading with this case. And since they're consolidated, I think both had to work together. So with all those reasons, I just simply look at this a little differently because it's not a new offense. While he was in bond, that he committed a year later, it was all in that same proximity within the last offense. But Mr. Deno, at least in the last year or so, has shown the court some change of his demeanor, testing, probation, rehab. He's done certain things that he otherwise would have done regardless. I think those are just positive things from Mr. Deno. And again, the pre-trial release letter that indicates that he's again on time. He's drug tested, they're all negative. And his first drug test wasn't even positive. That was a year ago. So that's all I judge. I think Mr. Deno is deserving an opportunity of being on the outside, not in jail, and just living that sober life and continuing to survive.
Thank you, Mr. Deno. Anything you wanted to say?
I agree with what Rob's got to say. I agree with what Mr. Coach got to say. I am on a good path. It's a tough fight. You know, I'm trying. I got a house out there and I want to use my house. 35 years. So yeah, thank you.
All right, well, I read through the report, so I'm familiar with what happened in this particular case. As the lawyers have indicated, we've been in court a lot over the past couple of years, so I'm obviously familiar with you. I presided over the jury trial that we had in the one case, and familiar with your background from the pre-sentence report in that case as well. You know, these are tough issues with your background. You're now getting prison guidelines. You know, the guidelines in this case are 5 to 23, so it could call for up to 2 years in prison. And when you look at your history in a certain way, you know, the report indicates you've done 9 prior jail sentences and 8 prior probations. And, you know, so you could look at this and say, jail hasn't worked, probation hasn't worked, and so is it time for prison? I mean, is that the straw that's going to break the camel's back and jog you into really working on this problem?
Your Honor,
I don't think that that's the right solution for now. because it does appear that you are taking some steps to try and get a hold of this problem and work on it and move past it. And there's mitigating factors here too, facts in this particular case. So there are a number of mitigating factors here that I think takes this out of that realm of prison. But I think you need to know that the next case you have, there probably isn't going to be jail at the low end of the guidelines. It's going to be only prison recommendation. So you're really up against it here in terms of community sanctions. I think the recommendation is reasonable. It's at the lower end of the guidelines. Doesn't call for prison time, does recognize the mitigating factors here and the work that you've been trying to put in during the pendency of this case. But it provides still a consequence to you and recognizes your past record as well. So 8 months in the Crawford County Jail is, again, almost at the bottom end of the guidelines. So I think it's a reasonable sentence. I think it accounts for your conduct in this case. I think it accounts for your past history. And I think it also recognizes the mitigating factors here. So the court is going to follow the recommendation. The court is going to sentence you to 8 months in the Crawford County Jail. You have credit for 22 days served. The court is going to order a crime victims assessment amount of $130. The court costs amount of $325. Attorney fees of $350 and $68 state cost. You have the ability to request an appeal of this sentence, and Mr. Germer, acknowledge receipt of the rates. Mr. Deno, you are remanded to the custody of the county. Where does you have to go, right?
Hey.
In jail.
He's not lodged here.
I don't think so.
Wonderful.
See, I'm going to bring in now another.
And we have another article.
Yeah.
Mr. Townsend is here, he's outside. Do I have a couple of minutes with him?
Yeah, I actually have to take another case. So, maybe 5-10 minutes.
Me, am I here for the other case?
No, it's a divorce. Oh.
Usually what they are, but not today.
Come back in 10 minutes. Just text me. I need to come.
Ms. Eckert, Chris Bell, I know we're a little bit ahead of schedule, but are you ready on your file?
I'm ready, Your Honor.
Okay, so we'll call the matter of Robertson versus Angerer. This is case number 2311306. And Ms. Chris Bell, if you could put your appearance on the record, please.
Yes, Your Honor. Robert Ecker Crispell, appearing on behalf of Vincent Robertson. He is the plaintiff in this matter. He is seated to my left, Your Honor.
All right, and this is your motion here today for entry of a default judgment.
It is Your Honor. We've filed notice with the court as far as today's hearing is concerned.
All right, and reviewing the file here, it does appear that the defendant was properly served with the summons and complaint, that there has been no answer. A default was entered back on July 10th. And there's been no appearance by the defendant. Is there anything that you wanted to say in support of your motion for judgment here today?
Your Honor, I think my default judgment says it all, that we're seeking to have a default judgment granting ownership of the property by specific performance to my client.
Okay. All right, based on the pleadings in the file, the failure of the defendant to defend or otherwise appear, the court finds it would be appropriate to enter that judgment. I do have the proposed judgment that you submitted. I'll sign that with today's date. Is there anything else that I can address for your side today?
Nothing that we can address in the case, just for procedure wise. Do we have on postage paid envelope for the judgment to be sent back?
I don't see one in the file.
There very well could be, that would be in my office, which I'm currently not at.
Oh, okay, thank you.
So maybe just check with Sarah later today or tomorrow maybe and see. Okay.
We'll do that. Thank you, Sarah.
Yep, thank you.
Okay, thank you. That's all for today. You're free to disconnect at this time.
Okay.
All right, we'll be in recess until on the record in People versus Marvin Townsend, case number 235215 and 5216. Back to council for your appearance.
Sierra Cook on behalf of the people.
Thank you, Roberto, going with you, Mr. Townsend, he's just like,
And how did we want to proceed on these files today?
Judge, today is our first pre-trial in this matter. This time I would simply ask you just not to dispense with trial. They're both two separate files. I don't believe there's gonna be any consolidation issues. The two separate incidents, witnesses. So we can just put them in trial after the pre-trial date.
Okay, Ms. Koch, as to the consolidation issue,
I don't have any issue with the consolidate. We're not gonna try to consolidate. They're 3 months apart. They're different officers in different circumstances. I will let defense counsel know. I have to review the reports. I think I only charged one officer. If we go to trial, I may add additional counts if there were additional officers, but I don't recall the circumstances. But there has been a very good plea offer in this case. We may get this case resolved. I don't know.
all right, so I'm gonna set 5216 for trial first. That's the older one, even though it's got the newer number. But the offense date is earlier, 1 day, Ms. Koch.
Yes.
I agree.
Okay. Set it for 1 day jury trial. What's next available date? With the final status conference and plea and motion cut off prior to trial. And then I'll also set 5215 for a status conference on the date of the final status conference of 5216. So we'll discuss both cases if we need to at that time. Those are the other scheduled dates.
No, thank you.
No, sir.
Mr. Townsend, any questions about how we're going to proceed with your case?
No.
Thank you, that's all. Okay, next hearing's at 3:15, we'll be off the record. versus Mellon, case number 235217.
Your folks on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Kate Mellon. Your Honor, there's a plea offer in this matter. Ms. Mellon pled guilty to an attempted resisting and obstructing the police officer, then count one, and any enhancements would be dismissed. There'd be a 1-year maximum on that attempt. And that's her intention, is to enter that plea agreement today, Your Honor.
All right, Ms. Koch, is that a correct statement of the plea offer?
It is.
Ms. Mellon, have you had a chance to talk to Mr. Thompson about this plea agreement?
Yes, sir.
Is that how you want to go forward today? Are you ready? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Mellon, are you currently on any kind of probation or parole?
No.
And you understand that the maximum penalty you could face for attempted resisting and obstructing is up to 1 year in jail?
Yes, I do.
With that in mind, what is your plea to that charge today?
Yes.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and question those witnesses. You have the right to have the court order any witnesses on your behalf at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty today. If anybody threatens you with anything, you got to plead guilty. Has anyone promised you anything other than what we said here in court?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Okay. This happened on March 4th of this year. Is that the correct day?
Yes, I do.
On that day, were you here in Crawford County?
Yes, I was.
Did you come into contact with a deputy from Crawford County, Deputy Taylor?
Yes.
And was Deputy Taylor wearing his uniform?
Yes, he was.
Did you know that he was there performing his duties as a police officer?
Yes, I do.
Okay. And what happened that you did to try to resist?
Well, I ended up sitting over there by the stop sign. I wasn't really aware that I had those warrants. Well, I ended up going in the trailer and just laying down. And yeah, like 10 minutes later, 2 officers pulled up in the driveway and I'm coming in the trailer and coming to get me.
Okay. So when you first saw Deputy Taylor, did he tell you to stop or something like
Yeah,
that?
he told me to get up.
Okay.
He told me to get up
And
because
did
I had
you,
to work for my arrest.
and did you not obey those commands?
I told him to give me a second, and he didn't end up giving me a second, so he ended up just grabbing me and slamming me on the bed and putting my hands behind my back and everything. So I was trying to get up. So
Mr. Thompson,
When he was giving you lawful commands, were you resisting?
no, I was not. I was getting up. I was getting up, and
And then when he started reaching to grab for you, were you compliant with being detained like that, or did you reach away or resist?
I did not reach away or resist anything.
Do you believe that you resisted the officer?
No, I don't.
Do you think you obstructed him?
No,
You're not.
I feel like he was.
Could I ask some questions?
sure.
Ms. Mellon, did Deputy Taylor come to the camper where you were staying at?
Yeah, he came in, just walked right in.
Yeah, and did he identify himself as a police officer? Were you in the back of the camper?
Yes, I was.
Were you hiding underneath the floor with a blanket? I'm sorry,
No,
on the floor under a blanket in between the wall and the bed?
no, I was laying down.
Okay. And did he instruct you to get up?
Yes, he did. And
Did he tell you that if you didn't get up, he was going to tase you?
he did say that.
And did he end up ordering you up multiple times before you did get up?
He warned me 3 times while I've been in the process of him telling me that I was getting up. And he went to go snatch me up and slam me on the back.
How many times do you think he told you to get up before you actually got up?
Honestly, it was only once. By the time I was getting up, he already said it 3 times in a row.
Yeah, no, we can set the matter for trial.
Yeah, I think we have an intent problem here. She didn't get up right away. She's indicating that. And let's get up and comply. So. Calendar with the final status conference. I think that's appropriate. Sounds like a one-day trial. So
Yes, I'll just play the body cam and have the two officers.
I would agree 1 day would be sufficient.
any other scheduling matters that we need to address, Ms. Coke?
No, thank you.
Mr. Thompson?
No scheduling matters, thank you.
Okay, so Ms. Mellon, you're gonna get some notices in the mail. We're gonna have one final hearing before the trial date, and then you'll get notice of the trial dates as well. It's important that you stay in touch with Mr. Thompson so that you're prepared for both of those hearings, okay?
Okay.
All right, thank you, that's all.
Thank you.
Sure. People versus Austin Checks, case number 235172.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Austin Checks. Your Honor, the court is aware we had a conference call with the court where we described the circumstances whereby the prosecutor has made an offer of HIDA. HIDA eligibility, as I review the whole thing, is going to determine on SORA eligibility. Obviously, you can't seal a file if you're also required to make a public listing of an individual. So the SORA factual finding the court would have to make to keep this non-public would be that the ages involved are less than 4-year difference, that the victim was between 13 and 15, which are, I believe everyone agrees to, and then whether the sexual activity involved was consensual. As we've described with the court, it would be appropriate for the court to have a comms hearing to make that factual finding, and we are scheduling, I believe an hour would be sufficient to schedule that to determine if the court will accept such a plea. Thank you.
All right, Ms. Coke.
That's correct. I believe Mr. Thompson's going to set that for a trial. We will subpoena the witness and we will take testimony at that hearing and have the court, and the court will have that information to make those determinations.
All right, so once the court makes that determination, then Mr. Thompson, your client would.
His intent would be to, yes, our plan is for the court to make that finding, for him to be eligible for HIDA and to enter into that plea, yes.
Okay, and if the court determines that he's not, then
We'll have to go proceed to trial, I guess. If he's ineligible, that leaves us with very few options, as you know, between Ms. Coke and myself.
Okay. All right, so Ms. Coke, you're gonna set that for hearing?
I thought Mr. Thompson was going to, but
I'm happy to, Your Honor. I haven't done it yet, but we spoke on Friday and I will do that.
Okay, so Mr. Thompson, if you can contact my office, get a time for that hearing date, and we'll proceed from there. Mr. Checks, you just need to make sure that you stay in touch with Mr. Thompson so that you're prepared for that hearing. That's all for today.
All right.
it's questionable.
Okay.
Was it attempt CSC3?
What is?
After the attempt CSC3 hideout. There's a
Versus
baby.
Brandy Welch, case number 2250.
Sierra Coke on behalf of the people.
Jason Thompson.
Set for sentencing hearing. The record should reflect Ms. Welch is present here in the courtroom today. I did have a chance to review the pre-sentence report. I also received a letter from Trey Ayers, support of Ms. Welch. I had a chance to review that as well. Ms. Welch, have you had a chance to go through the pre-sentence report and talk to Mr. Thompson about it?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the guidelines?
No challenges to the guidelines, Your Honor.
Ms. Coke?
No, Your Honor.
Any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the guidelines?
No, I believe it's scored properly.
Anything on behalf of the people for allocution today?
Your Honor, I did not get a copy of Mr. Ayers' letter of support, but I frankly know what it's going to say because we've been dealing with this for a while and he's met with me on several occasions. At this time,
Did you want to have a chance to review that?
I don't. The amount of meth that Ms. Welch and Mr. Deno had was pretty significant. The court sentenced Mr. Deno to 8 months. To be honest, Ms. Welch probably would have scored higher. She has a worse criminal history. She was on bond for possession of meth out of Roscommon when she got this case. While she was on this case, she tested positive. Her vehicle was stopped, I believe, a week or two ago that led to her bond being revoked. The car was impounded and more meth was found. And that was following a positive drug test for meth. I don't know what Miss Welch needs to do to realize that this is not working out for her. She seems very nice. She testified as a victim in a case Friday. She just has a series of bad circumstances that she seems to put herself in and bad choices that she continues to make and really struggles with drugs. I think the recommendation is appropriate. I think she got the better end of the case because Mr. Deno decided to take the higher, which was what the plea was. One was going to plead to possession, one was going to plead to maintaining. And they went back and forth, so it took a while to get it resolved. I will be charging her with possession of meth. I just got the police report for the next case, but I haven't charged it yet. So I'd ask the court to follow the recommendation. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. A few things, first of all, as well, did get the lesser plea that was by offer of the prosecutor. I don't believe it's appropriate to suggest that should have been different. That was the prosecution's offer. Mr. Deno, at the beginning of the case, claimed ownership of the substances involved. You know, that's what he said in the initial police report. That's what he said in the plea hearing. That's consistent with the offer of the prosecutor. The reason we should be going backwards on that. Ms. Welch would ask that you consider, Your Honor, when you look at the credit on the page 2 of the PSI, it does indicate his credit was accurate. She's also missing out on credit. There's a note that says under sentence and docket 2022F991FH. I believe she served an additional 51 days during the pendency of this case. I'm not asking for credit under Gibbons, but I'm asking the court to consider that. You know, the prosecutor, you know, wants to present that this is a situation where Ms. Welch needs to make a realization. I don't think that's accurate. I don't think that's an accurate summary of how individuals struggling with substance abuse process issues and how they heal from and grow from issues. Ms. Welch has made tremendous strides. She's going to address the court. I'll let her, you know, enumerate those, but Ms. Welch has made tremendous strides in her life over the course of this case. There's visible differences. Been working with her for a while. She's doing very well in her life. I'm not saying she's never had a relapse. Relapses occur. They're part of recovery. Her overall trajectory is very much an upwards trajectory. She received a strong letter of support. She has a good work history. I think that's all reflected in the report from Northern Michigan Community Corrections pretrial supervision report. I assume the court received that. And I'd ask the court to consider all that. I don't know what the real value to that recovery process would be from a jail sentence here. Ask the court to consider whether her work obligations, her family obligations, whether continuing to learn how to handle those in the community is not a better use of her time. And a better use of her recovery path. So I'd ask the court to consider an order of probation, a sentence of probation of this thing.
Thank you. Ms. Welch, anything you wanted to say to that?
I just like to apologize for my actions which have brought me before the court today. In the 18 months since the charge has occurred, I've obtained a job as a manager position where I work 6, sometimes 7 days a week. My few and far in between supervised visits, I now have my kids 5 days a week. Regularly, I've obtained stable living conditions for them and me as well. My significant other has major life-threatening surgery that he'll need to be assisted and taken care of afterwards. And he has no family here to help with that. I'm just asking the court if they would take in consideration probation or rehab in lieu of some jail time.
Like I said, I did read through the letter. I read through the report. I did receive the pretrial services report as well. I did review that. So looking at the circumstances here, looking at your past record, certainly, this has been an ongoing issue for you. You've been to jail a number of times. You've had a number of different probationary terms. You're starting to get to the point now where you're creeping up on prison guidelines. This was 0 to 17, so technically the court could look at prison time. And at some point, probation isn't successful when jail isn't working to deter the conduct. Then that's really the next step. If there's nowhere else to go outside of that. So this is something that you really need to concentrate on working at. The recommendation in this case is for the lower third of the guidelines. I think it's a reasonable recommendation. It accounts for your conduct in this case. I think the fact that you tested positive while on bond is I understand relapse. I know they happen. But when you're under the microscope, it's even more important to do everything that you can in terms of getting treatment and help while you're on bond to prevent those relapses. Unfortunately, that didn't happen in this case. But the sentence in the lower third of the guidelines, I think, recognizes all the aggravating factors, but also recognizing the mitigating factors in the work that you have done, which is why I don't think a 12-month or a 16-month sentence in Department of Corrections is appropriate. So balancing all of those factors, sentence in the lower third, I think, accomplishes the goals of sentencing. So the court is going to sentence you to 5 months in the Crawford County Jail. You have credit for 68 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. If you are able to get into a residential treatment program, whether that's 30 days, 60 days, 90 days, then I would allow you to be released early from that 5 months to go to inpatient rehabilitation and to get day-for-day credit off the rest of your sentence and hold any remaining sentence in abeyance. Successfully complete that. So if you can work on finding a bed and getting in, I would absolutely consider giving you an opportunity to go to rehab as part of your sentence. You do have the ability to appeal this sentence. Mr. Thompson provide Ms. Welch with her appellate rights so that you can acknowledge those, please.
Yes, Ms. Welch did already acknowledge those. That's the court.
Your Honor, just to clarify, so when we do the, I don't know how we're doing the orders on the residential, but is she eligible now or is it the end of her sentence? She doesn't get credit if she's not successful, and she has to sign a release.
No, she's eligible now, and she's already got 68 days of credit. You can get into a program. I agree with Mr. Thompson, if we get you some treatment that would
Thank you.
do more than jail time.
Thank you.
All right, thank you. All right. Mr. Thompson, quick question.
Recorded, People versus Marcus McKay, case number 225119. Mr. McKay is present here in the courtroom today. This is the date and time set for sentencing hearing in this case. Mr. McKay, have you had a chance to go through the pre-sentence report and talk to Mr. Germurthy about that?
I have.
Mr. Germurthy, are there any additions, deletions, or corrections that need to be made to that report?
Judge, the only correction I would ask them to go to the report is to CFJ 145, page 1, where it says plea agreement. I think the plea agreement should say you can find one dismiss the rest the way it says, and no more than the middle of the guidelines. And then I spoke with Mr. Haven and Ms. Koch that the middle of the guidelines will be 116 months, 116. So pursuant to the plea agreement, that's that he would not be sentenced to more than 116 months.
Ms. Koch?
That's a correct statement of the plea agreement, and I think it's appropriate to put it in there. I did speak to Mr. Haven, and he does agree.
Okay, thank you. Any other corrections?
No,
Any challenges to the scoring of the guidelines?
no.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocation?
You know, when we ran the first trial in this case, Mr. McKay ended up getting a possession. I think he had a chance to turn his life around. He didn't. I've dealt with him pretty regularly, and I think he's probably earned this sentence. He put himself in a position where his guidelines are incredibly high. Had we gone to trial and we had been successful in all these different cases and the intimidation, I mean, he could be looking for 15, 16, 17 years. And I think the recommendation is appropriate. I just asked the court to follow it.
Thank you, Mr. Germurthy.
Thank you, Judge. Mr. McKay is 39 years of age. Clearly, he has an extensive record. But Mr. McKay, again, was just, my understanding was caught up with other individuals with children and hanging out with them. He was just caught up with the drug environment in the community. Mr. McKay has a GED, he's employable. He does have some good strengths going for himself. However, this is going to be a lengthy sentence of 160 months, which is I think about 9.5 years. For 361 years, I'm sorry, 361 days. So again, I would simply leave that in the discretion of the court. Based on the mitigating factors, it doesn't depart downwards. Clearly, the court has that discretion, but I would leave that in the court's discretion to make that decision.
Mr. McKay, anything you wanted to say?
No, sir.
I read through the report, so I'm familiar with what happened in this particular case. I presided over the previous trial that you had, so familiar with that in terms of your background, that particular case. Of course, there's a lot of information in the report about your background and circumstances as well. Certainly, you didn't have many benefits starting out to get you on the right path, and you got off on the wrong path pretty quickly and have continued down that path throughout most of your life. Unfortunately, you probably, I think, never really had the opportunity to have proper guidance and care that I'm sure that played into how you're in this case, the guidelines are 87 to 145 months. The agreement calls for a sentence of 116 months. That's in the middle of the guidelines. I think a sentence within the middle of the guidelines is appropriate. It accounts for your past history, your conduct in this particular case, and also recognizes some of the mitigating factors that happen in the guidelines. The court finds that the sentence as part of the plea agreement is appropriate, and the court is going to follow that and sentence you to 116 months to 20 years in the Michigan Department of Corrections. We do have credit for 361 days served, crime victims assessment of $130, court costs of $325, state costs of $68. You have the ability to seek an appeal of this sentence. Can you provide those appellate rights to Mr.
I've already gone over his appellate paperwork. It's,
Oh, is there anything else that we need to address for the record today?
No.
Mr. Gerber?
no, sir.
Violation.
Judge, we do have a separate probation violation file. So that's a separate file, wasn't noticed for today. But I think Ms. Medlis pulled that file, so we can address that if you would like to call that file.
Judge, I did not pull that file because my understanding was it was just going to be dismissed. So there was nothing on the record.
Mr. Haven?
Yes, Your Honor, in file 20-4708, in light of this sentence on this newest file, I would request that the violation be dismissed and he just be discharged from probation unsuccessfully.
All right, court will order that the probation violation be dismissed and that Mr. McKay be unsuccessfully discharged as part of the resolution of that file. The court will preserve any outstanding fines and costs that remain. Anything else, Mr. Gerber?
No, sir.
Your argument to the custody of the statements.
Supposed to be in rehab.
Mr. McKee, are you able to hear me all right?
Yes, Your Honor.
Okay, all right, we're on the record in People versus David McKee, case number 235166. The record should reflect that Mr. McKee is present today by video, by prior approval of the court. If I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Honor. Webb Gorman, on behalf of Mr. McKee. He's appearing from the Bear River Health Rehab Facility in the courtroom.
All right, this is the date and time set for sentencing in this matter. Mr. McKee, have you had a chance to go through the pre-sentence report and talk to Mr. Germerthy about that?
Yes, Your Honor.
All right, and Mr. Germerthy, are there any additions, deletions, or corrections that need to be made to that report?
No, Judge.
Are there any challenges to the scoring of guidelines?
No.
Ms. Koch, do the people have any additions, deletions, or corrections?
No,
Any challenges to the scoring?
no, I think it's scored properly.
Anything on behalf of the people for allocation?
This is a hard case, Your Honor, because he has such a terrible criminal record. I mean, he's 67 years old. He has 8 felonies and 17 misdemeanors. You know, the recommendation is for MDOC. I know he's taken this seriously and gone to Bear River, but I mean, at this point, his guidelines are really high because of the choices he's made. So I think whatever the court decides to do would be appropriate. Thank you.
Thank you. Mr. Germerthy?
Judge, I would agree with Ms. Hope. This is a difficult case, given that we don't have sobriety court, and I have a defendant who indicates to me that this is a wake-up call and taking sobriety seriously. Mr. McKee is on an alcohol tether, as the court already has that tether while he's in treatment. He is in treatment. That's where he's appearing from. I also had sent an email that I received late Friday from his counselor, and I know the court received it, but
I did.
Thank you, Judge. And it addresses and highlights at least the things that Mr. McKee is handling while in treatment. Looking at his history, he's never had treatment. He's never had any serious rehab. And then again, I would just address to the court that his last real involvement with the court was in 2017 for a driving license suspended. I believe the domestic violence was dismissed, and then prior to that was a 2015 case with the R&L with a police officer, which was dismissed, and then there was aggravated stalking prior to that he was on probation for 5 years. So it has been a few years. I wouldn't say that this has been a lengthy timeframe for Mr. McGee that he hasn't been involved with the criminal justice system. There has been some timeframe of about 5 or 6 years that he hasn't had involvement with the criminal justice system, and he's taking his treatment in a serious manner. Again, these are just addiction issues that I think the court understands that people deal with. I think the court is very well familiar with addicts and how they respond. And then I think the court is also familiar when somebody does take their addiction seriously, that seeks treatment and then observes how they, handle and take those things seriously. And that's the case I have here, that Mr. McGee has a history. He's taken advice and counsel to get help. He's getting help. He's in a treatment facility. Speaking with his counselor, my understanding is he gets evaluated every 2 weeks to 4 weeks to determine the length of time frame that he's going to stay in treatment, with an out date based on how he makes progress to an intensive outcare program. So at this point, it looks like he's going to be there about 90 days. But again, I will just leave that in the court's discretion, given that the recommendation is a prison recommendation. The guidelines are 7 to 23 months. The court certainly could deviate downward within the sentencing guidelines and hold some jail time in advance while he's in treatment, and craft a sentence that makes sense with the rehabilitative services that are in place that Mr. McGee currently is following. So I'll leave that to the court's discretion.
All right, thank you. Mr. McKee, anything that you wanted to say today?
Yes, Your Honor, I have been on a bad path for years, not realizing that my addiction was so serious. I've came to this facility and they're basically reprogramming me, lack of better words, to be serious about my recovery. I have learned already a lot of things that I can apply to the outside, and given the chance, I would like to follow through with that. I think I can become a very sober person and not being in danger to anybody. Thank the Lord that I didn't hurt anybody or endanger anybody in my alcoholism. Like I said, given the chance, I think I can apply these tools to continue with my sobriety and the outpatient treatment. If incarcerated, I will lose my Social Security and my home, and I'll basically be homeless when I get out. And like I said, I beg the court to consider letting me continue with my sobriety and follow up with intense outpatient treatment and become a productive member to this society. Thank you, Laura.
All right, I did read through the report, and this is a difficult case to try to determine what is really what's best for the community. Mr. McKee, your record is really, you know what your record is, and it's extensive, and it covers really almost every category of the type of crime that a person can commit. There's financial crimes in there, forgery, there are theft crimes, there's some assaultive crimes, stalking, and then of course the operating while intoxicated offenses. And over that period of time, you've amassed 8 felonies, 17 misdemeanors. When I look at what kind of intervention the court can have, you've been on probation 8 times, jail twice, and 2 prison sentences. So, at 67, you kind of run the gamut of just about everything that the corrections system is set up to deal with. And so, I don't know how effective any sentence that the court imposes is going to be, whether it's strictly punitive and following the recommendation and sentencing you to prison and trying to craft a more rehabilitative, forward type sentence, whether that would be successful or not. Because all the interventions up till now have not been successful. The only difference that I can see is, at this point, in seeking inpatient treatment at your age, perhaps you are ready to move on and do something different at this point. But only time's going to tell on that. So the question still comes down to, is it going to be better for the community, again, to sentence you to a prison sentence, or to give you an opportunity to continue with rehabilitation to see if that, is going to have an effect. And so, in my view, sentencing you to prison at this point isn't going to really accomplish anything. We've already done that. I think giving you an opportunity here with some probation and jail time held in abeyance is going to give you an opportunity to continue with the rehabilitation with a really large hammer at the back end of that. If you have any problems on probation, if you leave treatment before you successfully complete it, under the guidelines, I've got up to 23 months of prison. And at that point, I'm not going to really have any reservations to sentencing you to the maximum time in prison under the guidelines. Because if it ends up going that way, that'll be a pretty clear signal to the court and to the community that that the rehabilitation just isn't going to work. So what the court is going to do is place you on probation for a period of 18 months. I'm going to adopt as the conditions of that probation all the terms and conditions listed in the report, or I'm sorry, all the standard terms and conditions of probation, including that you continue with and successfully complete the treatment program that you're currently in. The court is going to sentence you to 12 months in the Crawford County Jail with credit for 24 days served. The court's going to hold that time in abeyance to be served at the discretion of the court. The court is going to order restitution in the amount of $100 of OWI tested reimbursement to the Michigan State Police. A crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. The court is going to also include as a condition of your probation the alcohol tether. Again, that's for the safety of the community. We need to make sure that your alcohol use is closely monitored, to make sure that you're remaining sober during the time that you're on probation. The court is also going to impose would that be a $60 fee, Mr. McDowell?
So so you want him on scram on probation? Okay, yeah, it'd be $60.
Okay, so the court will impose a $60 supervision fee while you're on probation. You do have the ability to appeal this sentence. We'll provide you with an acknowledgement of those appellate rights. If you haven't already received them, we'll send those to you. And that will explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with an appeal. In terms of the probation, Mr. McDowell, are you going to be the supervising agent?
Not 100%, Judge. I don't do scram usually, so we'll have to work that out, but I'll get the order together.
All right, and will somebody be contacting him there? Does he need to take any steps?
Yeah.
I've got the number to the counselor and the extension,
Okay,
and if they don't answer, you leave a message, but then Mr. McGee will call back.
all right, I'll get that from Robbie.
Yeah, because that was the same number I passed along in that email to everybody.
Yes, but I've got the extension to Mr. Paul Keller. Yes.
Okay. All right, so Mr. McKee, just follow up with any contacts you get from the probation department. That's going to be very important going forward, okay?
Your Honor,
Yes, Your Honor.
Yes.
I just want to confirm, I think the court said it somewhere in there, but he's ordered to complete the Bear River rehabilitation as part of his probation,
Yes.
right? And does he do the scram while he's in Bear River, or does that start when he gets out of Bear River?
He's already doing it now. It should continue.
It's just different because he's on pretrial services now.
Okay,
So once he's sentenced, which he is now, I'm going to guess that they're gonna take that off him. If you want him on scram on probation, then that would be done through us.
yeah, I want that as a condition immediately or at all times, so if we need to fill that gap between when pretrial takes theirs off, when we get one.
He's gonna need to come here and do that.
Okay.
Let's find out. Mr. McGee, are you able to come here to take that tether off and get on scram through probation and then go back to treatment?
That's something I'd have to talk to the counselor about. I have it, my tether is on now, my alcohol tether.
Okay, we'll work that out, okay, Mr. McGee? But you
Yes,
have no room for any screw ups, no room for any mistakes, any error.
I'm planning on getting in the pointing in the right direction. I
Okay.
learned a lot of tools to gain sobriety, and they're teaching me how to rethink, basically.
And that's all good, but I just want to remind you again, and I'll call you, but again, you have no room for any error.
Yes, sir.
Okay, that's all for today, Mr. McKee. The court's gonna go ahead and disconnect this time.
Thank you, Your Honor.
Good luck to you going forward.
Thank you.
All right, Mr. Bostic, are you able to hear me okay?
Yes, Your Honor.
Okay, we're on the record in People versus Anthony Davis, case number 214941. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Good afternoon, Your Honor. Nick Bostic on behalf of Mr. Davis.
All right, and Mr. Bostic, I don't know, Mr. Davis, I don't see him present in the Zoom waiting room. Can we proceed with this hearing without him present?
Yes, Your Honor. It's actually possible he may have been released, but either way, I will waive his presence for this legal issue.
Okay. And we're on the record today for purposes of Mr. Davis's challenge to the court's ordering the payment of attorney fees for the court-appointed counsel. And Mr. Bostic, was there anything that you wanted to address for the record on that issue?
No, Your Honor, but just so the record's clear, we had, I think at the time you ordered this, court costs were still in play, but then People v. Johnson, and I acknowledge that that last published opinion is controlling, so that's off the table. The only thing as for the attorney fee assessment is I'd reiterate what was in my motion, and that is that the partial indigency must be determined by the local public defense system, not by the court. So other than that, I'd rest on my brief, Your Honor.
All right, thank you. Mr. Thompson. Mr. Thompson was trial counsel for Mr. Davis, and I asked Mr. Thompson to attend this hearing today because I think along with the issue of MIDC determining eligibility rather than the court, under the current case law, the court does have to make some factual findings regarding the amount of attorney fees. And so, Mr. Thompson, are you prepared to address that today, or should we set this for an additional hearing?
Your Honor, that's going to depend on the level of specificity the court is looking for. I don't have each monthly statement that goes back across 2 years and, two different calendar years, 2 bookkeepers, actually 2 different computer programs. I can testify generally about my hourly rate and give the court some estimates in terms of some of the work I did versus the amount the court charged, but I cannot provide specifics. I think the court put on the record the amount of notice I had. That's the reason. So whatever the court's pleasure is.
All right. Before we get into that, Ms. Cope, do the people have any position about the attorney fee issue at all?
No, well, I will say that we did a lot of stuff on Mr. Davis's file. So I don't have anything more to add other than we had a lot of hearings and a lot of conversations about this case.
All right. So Mr. Thompson, I'm just going to put you under oath real quick. If you'd raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. I'm going to conduct a little bit of questioning myself, and then I'll open it up for counsel to the extent that they have any questions. So Mr. Thompson, you were trial counsel for Mr. Davis, is that correct?
Yes.
And do you know approximately how many hours you would have spent on Mr. Davis's case during the time that you were counsel of record?
I don't have the exact totals, Your Honor, but I'm confident I spent over 10 hours on this matter.
Okay. And what is your typical hourly rate?
For appointed work with the county, I charge $120 an hour, Your Honor. For that work, that's my rate. For private clients, it's currently $250 an hour.
Okay. And did you receive compensation from the county for your representation of Mr. Davis?
Yes, and we bill the county on one monthly invoice, which is part of why I don't have, I can't just press in either of the billing software, just press Mr. Davis's name. It gets integrated into a larger bill. So I did bill it and I was paid for it.
All right. Do you believe that you were paid in excess of $350 for your representation of Mr. Davis?
Yes.
All right. Okay. Thank you. Mr. Bostic, did you have any questions for Mr. Thompson?
I do, Your Honor. Mr. Thompson, do you recall that there were 2 files for Mr. Davis that tracked each other through the system?
Yes, we bill by the defendant, and thank you for raising that. I didn't address that, but yes, those would have been billed at the same time. But yes, he had 2 files. He had 2 separate felony complaints that arose, I believe, weeks apart.
So the 10 hours is total for both file numbers?
Yes.
If you are asked to divide between the 2 file numbers, will that even be possible at this point?
I've never done that. I always worked on this, given that they arose close. The only thing that would have been separate would have been perhaps the first preliminary examination, although that might have even been a joint one. But no, that's not how it was ever billed, as separate, distinct files. It was always billed as one client.
Well, right, I understand that when there's more than one case, but is it possible for you to go back and determine the time spent on the 2 separate files?
I could attempt. It would probably end up being very much a division by 2. Although I guess I hadn't thought about that. It's very likely that all the work I would have had to do would have been required, whether there's 1 file or 2. So I don't know how to answer your question. I'm sorry.
When you get one of these appointments, are you ever notified by the local defense authority as to whether or not the client is partially indigent?
That is not a term that I've heard in the appointments. What I've always heard is either an individual qualifies or does not qualify based on whether they can retain an attorney. So I don't believe I've ever been advised someone was partially indigent.
And even if they were, you would bill as you do and let the court appointed authority figure it out?
Yes. I would apply the same rate, and if the court was determining that the individual was partially responsible, I would bill the same rate and divide the bill as I was instructed to.
I have no further questions, Your Honor.
Thank you, Ms. Coe.
Mr. Thompson, you're the MIDC Defense Contract Administrator, is that correct?
That is correct.
On 10/21/2021, my office sent you 2 separate emails with the WatchGuard videos. Did you watch those videos?
Yes,
I sent the plea offer to you on 10/21/2021. Did you review that plea offer and then discuss it with your client?
that offer as well as the 10/29 plea offer, yes.
On 11/2/2021, we had court for Mr. Davis, and this is all just in 4-1. I'm not doing anything else with the other file. We had court, at which time you told the judge that the prelim is going and you were present at that court hearing. Is that correct?
That is true.
On 11/16/2021, you ran a preliminary examination in front of Judge Burmeister. That was bound over. You ran that preliminary examination. Is that correct?
Yes,
Okay. Not only did you run that prelim, did you also prepare for that prelim
yes,
ahead of time? On 12/9/2021, we had court. Mr. Davis failed to appear and bench warrants were issued. Were you present at that court hearing?
I was.
Mr. Davis was then arraigned on those bench warrants on 12/20/2021. Does that sound correct?
That does.
He was issued new bonds. Were you present for that?
I don't know. Our arraignments are handled as needed and to expedite them, and that document is not in front of me, so I don't know if that was me or the other 2 contract attorneys who would have covered that in custody arraignment.
But one of the court appointed attorneys would have covered that hearing. Is that correct?
Yes, yes, the county
And
would pay for an attorney at that in custody arraignment. I just don't know if it was me.
On 11/18/2022, we had another hearing setting both cases for a jury trial at the defendant's request. We discussed a final status conference and motion cutoff dates. Were you present at that hearing with Mr. Davis?
I'm sorry, was that 1/18/22?
Yes.
Yes,
On 4/18/2022, you had a bond hearing. You argued the bond, the judge continued the bond, and we discussed Samantha needing to be subpoenaed at court. Were you present with the defendant at that hearing?
I was. I also filed that motion for a bond review. I think it was filed in February. We didn't get a motion hearing date for some time. And I had also filed a motion for a furlough. I believe I filed that in March, and I think the furlough occurred on April 20th, if I recall correctly.
And you prepared all of those motions, notice of hearings, proof of services, et cetera.
Yes,
And if I recall, on 6/9/2022, we had a sentencing hearing. The victim spoke. We talked about getting the days corrected. We talked about the second file. We talked about Anthony Davis's health issues, his need for surgery, his gallstone issues. We talked about the MDOC recommendation. You made an argument for concurrent sentence, and then the judge made a sentencing. Were you present for that?
yes,
And prior to that hearing, did you also prepare for that sentencing and go over the PSI with Mr. Davis?
yes.
All right, I have no further questions.
Thank you. Mr. Bostic, any questions to follow up on those of the prosecutor?
Just one, Your Honor. Mr. Thompson, based upon that detail that she was able to bring out, does that change your thought process about essentially, except for the prelim, this would be divided by 2?
I struggle with that question because if he'd only had one file, I believe most of that work still would have been necessary. So I guess I'm not sure if we're allocating between 2 files or if we're imagining that one file doesn't exist. If we're allocating between 2 files, I think dividing by 2 would be as good as any.
Okay. Nothing further, Your Honor.
All right, thank you. Prior to today, the court did have an opportunity to review the motion. At sentencing in this case, the court assessed $350 for attorney fees against Mr. Davis. Under the current case law, the court is authorized under current statute, the court is authorized to assess contributions for attorney fees to defendants. But as I stated at the beginning of the hearing, if challenged, the court has to make factual findings such that the amounts are appropriate and justified by the actual work that was done by counsel. In this case, Mr. Thompson has given testimony as to his usual hourly rate for court-appointed work. It's clear based on the questions from the prosecutor that Mr. Thompson spent time well in excess of the amount of time to justify imposition of $350 in attorney fees. In fact, court probably could justify amounts in excess of that, given the amount of work Mr. Thompson did on Mr. Davis's case and in reference solely to this file. So for those reasons, the court finds there is an adequate factual basis to assess $350 in court-appointed attorney fees. And so to the extent that Mr. Davis is challenging that, the court will deny that motion. And Mr. Bostic, I would just request that you prepare an order that just states for the reasons stated on the record, the defendant's motion is denied, and submit that under the 7-day rule.
I will, Your Honor. You know, I never received the new judgment from the sentencing on June 20th. So the reason I brought that up is because I'm wondering if that assessment was on there or not. Since you kicked it down the road, since I don't have it.
Usually those judgments of sentence will pull from what was on the prior sentencing, so it won't add.
Okay, we're checking on that right now, Mr. Bostic.
But
Okay.
It shows $198 on these.
So I'll do an order like you requested, but the reason I brought that up is because if it's not on the judgment, you might want to do an amended judgment.
It is not. The judgment shows a 198 total when his real balance is 1047.60. He has not paid anything on this case.
Okay, so we'll prepare an amended judgment that reflects the correct amounts.
All right, I'll submit an order as you requested, Your Honor. I'll just basically say denied for reasons stated on the record.
If you want to send it to me, I can just take it, I can sign it and take it over. We can do it as a consent order, so you don't have to do the 7-day notice and the judge doesn't have to hold it. Well, and I'll just bring it over to Ms. Pedler.
I'll work
Save
on
some
that.
process.
Okay. All right, thank you. That concludes the hearing and also concludes the court's afternoon docket. The court will be in recess.
Thank you.
And Mr. Thompson, thanks for your help today. Appreciate it.